Assalamualaikum warahmatullahi wabarakatuh. My name is Rahmawati binti Muhammad Yusof. I am from Department of Law UiTM Cawangan Johor, Campus Gamat, and my co-author is Muhammad Hidi bin Baharudin, a postgraduate candidate of Kuliah of Architecture and Environmental Design, IIUM Gombak. Today I am presenting a topic on protection rights of children in terms of family relationship from Islamic law and Malaysian law, a comparative analysis. Due to the outbreak of the COVID-19 virus over the world, majority of citizens in Malaysia all day at home during this MCO period. From the positive side, this order has built a stronger relationship between the parents and their children. However, Malaysia has recorded a rise in domestic violence cases involving adult children being abusive to their parents, increased by 20% during the MCO period. Children are an asset to the country and the link for the country's development in the future. Child protection refer to preventing and responding to violent exploitation and abuse against children. Other than the enactment of the Child Act 2001, legislation in Malaysia seems to silent on many rights of children. For protection to be in total, it is believed that thus children's rights should be made clear in all legislation relating to the protection of their rights. Therefore, this research work based on the premise that Malaysian law and policy is seen to be inadequate and require further improvement, particularly on children's rights. Protection of rights children in family relationship. Family relationship refer to family that consists of a legally married couple and their children. There are several rights related to children in terms of family relationship that will be discussed, namely the right to lineage, right to suckling, right to maintenance, right of gender equality among siblings, as well as the right to guardianship. The first one is right to lineage. Every child born in wedlock will be her husband's child. As the Prophet ﷺ said, the boy is for the owner of the bed and the stone are for the person who commits illegal sexual intercourse. For the right of lineage, Section 2 of Islamic Family Law, Federal Territories Act 1984, IFLA, stated that nasab means descent based on lawful blood relationship. Then Section 110 also has discussed the ascription of paternity. In the Evidence Act 1915, Section 112 stated that the fact that any person was born during continuance of a valid marriage between his mother and any man shall be conclusive proof that he is the legitimate son of that man. In the case of Wan Khairi bin Wan Azmi lawan Farah Nur Liliana binti Jawhari, the court in this case had decided that the paternity of the child to his own father who is an applicant. Second one is right to suckling. Breastfeeding is encouraged in Islam to be given to a newborn baby within 2 years as explained in Surah Al-Baqarah verse 233. This verse has dealt with suckling as a right of the infant and duty for the parents to be performed. The legality of suckling also supported by Sunnah Muhammad SAW, whereby the Prophet SAW postponed the punishment for Al-Ghamidiyah to enable her to suckle her infant. To IFLA, define suckling or for storage as the suckling of the baby up to sufficiency by a woman who is not its natural mother for at least 5 times during first 2 years of its life. Section 9.3 of the IFLA also explained the effect of suckling on marriage prohibition. The third one is right to maintenance. A father must provide nafakah to his children, as Allah Subhanahu wa Ta'ala said, but he shall bear the cost of their food and clothing on equitable terms. The Prophet ﷺ has said to Hind binti Utbah, take reasonably what is sufficient for you and your children. In Malaysian law, Section 72(1) of IFLA has specified that the father must maintain his children whether they are in his custody or the custody of another person. The duration of the maintenance order is spelled out in Section 79 of the IFLA, whereby the order expires on the child attaining the age of 18 years old. Apart from that, Section 73 deals with the power of court to order maintenance for children, and Section 78 explains the duty to maintain child accepted as a member of the family. Next, Section 80 deals with the duty to maintain illegitimate children. For the issue of neglect the child without the maintenance, Section 31 and 33 of Child Act 2001 deal with the ill treatment, neglect, abandonment or exposure of the children and the offence to leave a child without reasonable supervision. In the case of Nazaini binti Alias lawan Muhammad Sharif bin Muhammad Taib, the court ordered the defendant to pay the maintenance to the child RM200 per month. The fourth one is right of gender equality among siblings. A father must treat all his children equally, especially in the matter of giving gifts. The Prophet ﷺ has said, "Be mindful of your obligation to Allah and do justice in respect of your children." In Malaysian law, there is no specific act to deal with the right of gender equality among siblings. However, Malaysia has ratified Article 2 of United Nations Convention on the Rights of the Child, which stated on the protection from discrimination. In the Distribution Act 1958, Section 5 stated that there shall be no distinction between those who are related to the deceased person through his father and those who are related to him through his mother. The last one is right to guardianship or hadanah. The concept of hadanah refers to taking physical care of a child who is not able to do so by him or herself. It includes protection, love and care, education and shelter. The Quran did not address the question of hadanah directly, but general guidelines can be found in verse 7 Surah Al-Hajj, and whatever whereby Allah said, and whatever the messenger has given, you take, and whatever he has forbidden, you refrain from. In one situation, a woman came to the Prophet ﷺ and complained that her husband divorced her and wished to take her child away from her. The Prophet ﷺ said, "You have the first right to him as long as you do not remarry." Malaysian law context, guardianship should not be confused with custody. A guardianship is one who has power over a child upbringing, care, discipline and religion. Primary guardianship belongs to father as stated in Section 88(1) of IFLA or IFLA. And then Section 85 in IFLA also provide the custody of the illegitimate children pertains exclusively to the mother and her relation. Next, in Section 102 of IFLA, highlight the right of an orphan. Moreover, in Child Act 2001, Chapter 2 has discussed in detail about the right in the light of temporary custody. In the case of Abdul Rahman lawan Husna and seorang lagi, during the hearing, the child said that she wanted to live with her auntie, and the court decided that the child based on her maslahah and interest of the child. However, the appellant still can visit the child. As a conclusion, all these rights of children seem scattered and did not combine in one statute. Besides, there are a lot more of the rights of children that has not been identifying and highlighted in the Malaysian law. Therefore, it is proposed for more research should be conducted concerning the other rights of children, such as their fundamental rights. Thank you very much and Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. I am Tasneem binti Rahmatullah. I will be presenting to you about my topic, which entitles A Literature Review of Refugees in Malaysia and the Legislations Governing the Refugees in Malaysia. I would first introduce honorable audience to my topic. So we know half centuries before, refugees seeking temporary or permanent refuge have chosen Malaysia as a major destination from devastating conflicts in the region. According to history records, the affinities between the Muslims of Peninsular Malaysia and southern Thailand has caused an easy flow of people between the two countries for many years, as there is a great ethnic and religious connection between both communities in the country. The movement of people have been tolerated. However, it cannot be generalized that all those people from other countries fall under the international definition of refugees. So what is meant by refugees? Refugees are defined and protected under the international law. The 1951 Refugee Convention is a key legal document. So in legal prospect, this convention defines a refugee as someone who is unable or unwilling to return to their country of origin owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. So refugees are people who have fled war, violence, conflict, or persecution and have crossed an international border to find safety in another country. I would like to present to you an overview on the international conventions governing refugees. The first one would be the UDHR, or known as Universal Declaration of Human Rights. In Article 14, Clause 1, it is provided that some asylum seekers are guaranteed for asylum in other countries, or are guaranteed the right to seek and enjoy asylum in other countries. Subsequent regional human rights instruments have elaborated on this right, guaranteeing the right to seek and be granted asylum in a foreign territory in accordance with the legislation of the state and international conventions. This UDHR declaration is declared in the year 1948. Consequently, on refugees, there is the convention which is known as 1951 Refugee Convention. This is the controlling international convention on refugee law. And there is also 1967 optional protocol relating to status of refugees, known as 1967 optional protocol. Both of these refugee convention, especially the 1951 convention, establishes the definition of a refugee as well as the principle of non-refoulement and the rights afforded to those granted refugee status. Other than that, there is also Cairo Declaration. Cairo Declaration has been adopted and issued by the members of the Organization of the Islamic Conference, or OIC, at the 19th Conference of Foreign Ministers Islamic States in Cairo on 5 August 1990. On 30 June 2000, Islamic countries who are members of the OIC agreed to support this Cairo Declaration. It declares the purpose of the Cairo Declaration as a general guideline for OIC members in the field of human rights. The Cairo Declaration is also seen as a response from the Islamic country to the UDHR. Next, we will move in detail about the Cairo Declaration. It is to be known that the Cairo Declaration views human rights in terms of established principles by Islam. In its preface, the Cairo Declaration, among others, states, believe that fundamental rights and universal freedoms in Islam is part of the core of Islam, and that no one in principle entitled to eliminate it as a whole and partly or violate or ignore it in view of it a divine command contained in the books of divine revelation and sent through his last prophet to perfect the holy message earlier so as to make obedience to him a devotion, and neglect or violation of it is a highly hated sin. And therefore each person is responsible individually and the ummah collectively responsible to defend it. An overview on the current management of refugees in Malaysia. It must be reaffirmed that despite Malaysia not being a signatory to the United Nations Refugee Convention, which I mentioned before, the 1951 Refugee Convention, Malaysia does allow the presence of refugees in the country on the basis of humanitarian grounds and cooperates with UNHCR in addressing this issue. For example, on the Bali process, Malaysia has established a firm cooperation between the Malaysian government and UNHCR in managing the Bali refugees. But currently, administration of refugees in general completely lies under the management of UNHCR, which is established under 1951 Refugee Convention. Not having a legal framework, we can see that this clearly defines not having legal framework which clearly defines right of refugees and the duty of states in providing protection to them creates inconsistencies and chaos in management of refugees in Malaysia. So the issues which is happening among refugees in Malaysia is there is children born out of wedlock, undocumented children, and these children are being socially abused, like emotionally and psychologically, because they are not recognized when they have no documents identifying themselves. Then they can just be abused, and they can be detained. They can undergo detention by the Malaysian governmental force like police officers or lawyers. Other than that, there is also the urge from UNHCR in developing mechanism to assist detained refugees, because we have to first identify the meaning of refugees with migrants without or illegal migrants, or the migrants without document. Refugees are liable to protection. These migrants are not liable to protection. There is difference between refugees, asylum seekers, and the illegal or undocumented migrants. We have to first differentiate between these and provide a firm or solid mechanism to assist these refugees from being detained or arrested by the Malaysian governmental force. Other than that, children cannot access public education system. It is kind of unfair to the children where they cannot access education system, because education is very important for a human being. At least the basic education must be allowed to be accessed for these children. So there is some ghosting questions in this issue. To what extent has the government of Malaysia cooperated in tackling the issues arising among refugees and asylum seekers in Malaysia? The second one would be as a member of Organization of the Islamic Conference, OIC, which has been a signatory of Cairo Declaration, have the Malaysia government strive to establish social justice by referring to the origin of fundamental right and universal freedom according to the Sharia principle as stipulated in Cairo Declaration. For the third question would be, as an Islamic state, how can Islamic authorities in each state specifically carry out their responsibilities toward fellow Muslim refugees consistently without being bound to any legal basis? Is this possible? So I would like to suggest that to Malaysia as a member of ASEAN, it is encouraged for Malaysian states to undertake coordinated steps to share the refugee burden in the region. The second one would be to encourage all the states in Malaysia to fully implement the ASEAN Declaration, or known as Cairo Declaration, on the protection of refugees, as long as it is considered safe to implement it on the ground of maslahah. To government in Malaysia to amend, I would like to recommend it is important to amend the Immigration Act or enact separate legislation to legalize the status of refugees and asylum seekers in Malaysia. The last one would be to thoroughly observe if Malaysia as a state practicing Islamic law among Muslims has to the maximum potential exercise the obligation in providing refuge to the refugees and allow them to live their life humanely in a dignified way as a human being. So for further information and detailed elaboration, you can have access to my paper. So that's all from me for today. Assalamualaikum warahmatullahi wabarakatuh. Thank you so much for your time.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and very good day to all of you. First and foremost, I would like to thank the organizing committee of the INSLA2020 for accepting my paper. And my paper and presentation today titled Coroner's Preventive Role in Malaysia in Occupational and Industrial Calamities, a Fundamental Legal Review. For introduction, I would like to say and explain that our coroner and criminal justice. What is coroner? Coroner means a judicial investigator for the death, and the jurisdiction can be found under our Criminal Procedure Code from Section 328 to Section 341A. And under Chapter 9 of that particular Criminal Procedure Code, coroner's institution has been given a jurisdiction to investigate 5 important questions: who, when, where, why, and in what manner does the death occur. And from the case law, which is from Ri Loh Ka Keng case, and also from Public Prosecutor versus Shanmugam, Malaysia inherited the coronial investigation, coronial jurisdiction from the common law, and it derived the law from the UK. And coroners in UK has the public health apparatus role in prevention for future similar death via coroner's prevention report. So the next question would be, why coroner? Coroner and inquest are inquisitorial in nature, and it is not unlike the court that have adversarial in nature. And also we can see that under the coroner's investigation, the best evidence rules are not applicable, as in contrast in the judicial proceeding, in which the best evidence rules are very much applicable. And if you can see that the preservation on the right to life are the salient feature in which why the coroner's investigation and coroner's institution are still inexistent until today. And the coroner's prevention are the most important thing as for the sustainable criminal justice system. in upholding the right to life, in to ensure that no life can be taken away, and the sacred of life towards human being. However, the Malaysian Criminal Procedure Code, which give the coroner's powers, never being reviewed from 1974 until what we have today. And the relationship between the coroner's investigation compared to occupational death is that we can see that the statistic from 2009 until 2011 in UK, in which the verdict on industrial and the occupational death recorded the amount of 7,752 deaths occurred during the employment, in the course of employment. And in Malaysia, from 2009 until 2011, the number of 585 death investigated by our Department of Safety Health, or Department of Occupational and Safety and Health, and from that number, 968 deaths occurred was among the foreign workers during the industrial accidents. And we can see that under the Occupational Safety Health Act, Malaysia empowers the DOSH officer in holding inquiry on industrial death. However, there is no data on such inquiry under Section 34 that has been conducted. And worst come to us, the person who caused the death of the employee will be charged under the Penal Code for causing death, and he or she will be subjected to adversarial justice, which is more towards fault finding. That's why we need to have a coroner's preventive model. Why? Because it is the third independent institution to investigate death. It is not a fault finding but gathering all circumstantial evidence, and industrial calamities can be later on being mitigated or prevented for causing similar fatalities. So this is very important as to balance the interest between the public to know the actual cause of death, why it happened, maybe because of negligence, maybe because of the current practice, which can cause a similar death in the future. Therefore, what that I from this paper actually we try to say, and I would like to conclude that we need to have a coroner's prevention model for Malaysia. And the coroner's prevention model will be in the form of a simple report at the end of the inquest, to say that, look, the judiciary, based on the evidence being tendered to the court, there is actually a likelihood, the evidence expose the likelihood of the similar fatalities in the future. And also, the most important part, that the Criminal Procedure Code as well as the Occupational Safety and Health Act need to be amended as legal innovation to facilitate such model to be implemented in Malaysia, because without any legal review towards the law, it cannot be implemented. And the most important part, the DOSH and judiciary need to coordinate and to have a strategic cooperation in order to facilitate. So this is very important, and it comes to the end of my paper. Thank you for your kind attention. Thank you very much. Assalamualaikum warahmatullahi taala wabarakatuh.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you for the organizing committee, and congratulate for the success of this event. This presentation is on the indigenous peoples living in protected areas. We take a sample from Kampung Peta, Johor, on the impact of COVID-19. My name is Arif Fahmi Yusof. My colleague is Isawati Wu, and we are both lecturers from the Faculty of Shariah and Law, USIM. This the outline of the presentation. As introduction, everyone worldwide has been affected in some ways by the COVID-19 pandemic. However, it has been noted that there is a marked inequity in the impact and threat of the disease for indigenous peoples worldwide. The Malaysian Commission on Human Rights, SUHAKAM, has also highlighted that as the poorest and marginalized group in Malaysia, the indigenous people's difficulties have been further compounded by the COVID-19 pandemic. Therefore, access to medicines, healthcare, food, education, and livelihoods are badly affected. Kampung Peta is one of the indigenous people's villages of the Jakun tribe. It located at the remote areas, which is about 56 kilometers from Kluang Mersing Junction in the district of Mersing, Johor. Kampung Peta is orang asli villages, which is redeveloped under program penempatan tersusun, which was managed by the Department of Orang Asli Affairs, JAKWA. And Kampung Peta is adjacent to the Endau Rompian National Park and also Endau River. And it has become the main entrance of Endau Rompian National Park from the east side. Endau Rompian National Park was gazetted as a protected area under National Parks Johor Corporation Enactment in 1989. And in the same year as well, Kampung Peta was also gazetted as Aboriginal areas under Section 6 of the Aboriginal Peoples Act 1954 by the Johor State's enactment. Orang asli Jakun of Kampung Peta represents 2% of the whole population of Orang Asli in Johor. There are subgroup of Proto-Malays. The original settlements is around Endau River. There are about 200 peoples with 67 households. They practice traditional lifestyle, ancestors' belief, and speak Jakun language. The kampung is well equipped with good facilities as shown in the pictures. Land rights. There was a conflict as to the extent of the land rights of the Jakun Orang Asli in the area. In 2012, a notice was issued by the Mersing Land Administrator to vacate a particular area of land within the national park, whereas on the part of the Orang Asli, they continue to have customary land right over certain areas of land within the park. A case was brought to the High Court for a judicial review, contending the validity of the notice of the basis of their entitlement to the customary land. The High Court allowed the application, affirming that the Jakun communities have customary rights over the land that they have exercised since a long time, including to the areas that they access for hunting and foraging. The livelihood of Orang Asli in Kampung Peta. Their livelihood depends on natural resources with mixed activities such as farming, fishing, and hunting. As the village is located near the entrance of Endau Rompian National Parks, many are involved in ecotourism. Economic activities, as reflected in the photos, some operate boats for tourists and some others serve as tour guides to Taman Negara. But however, COVID-19 impact on ecotourism business. Number of tourists declines, and it affects the source of cash income. And most of Orang Asli rely on natural sources from forests. And consequently, food and other supplies are expensive due to distance from town and limited suppliers. Conclusion. From our quick visit to the village in March 2020, we found that even before the restricted movement order was implemented in last March 2020, the pandemic has impacted the livelihood of Kampung Peta people whose incomes are also dependent on tourism activities in the national park. With the effect of COVID-19 expected to last for years to come, it is important to ensure the policy development addresses the minority community groups who live in the rural area, including the national park. We are grateful to USIM for funding this research. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. I am Abidah Abdul Ghafar from Faculty of Shariah and Law USIM. I am talking about handling the perpetrator of domestic violence from legal perspective. So first of all, what is a perpetrator? Perpetrator means the person having family relations with the victim and for whom the victim alleges to have been subjected to an act of domestic violence. And this also includes any person involved in the domestic violence or in the accomplice of the crime. So in this regard, there will be laws applying to perpetrators, against the perpetrators. We have penal code, which deals with criminal offences and penalties, including the offences or the act of the perpetrator which amount to criminal offence and the penalties for such offences. And then the Domestic Violence Act 1994 recent amendment 2017 providing for protection for victims. These two laws should be read together. So Domestic Violence Act, or I will address as DVA, has gone through various amendments. There were twice amendments in 2012 and secondly in 2017. Okay, the Domestic Violence Act is an act to provide for legal protection in situations of domestic violence and matters incidental thereto. The DVA Amendment Act 2012 and 2017 provides more protections to abuse victims, regardless of age and gender. Amendments to DVA expedite safety measure and victims can get instant and comprehensive protection with the new Emergency Protection Order EPO. In 2017 amendment of DVA, it has covered 5 scopes. Firstly, the extension of interpretation of domestic violence to become more comprehensive to cover the needs of victims and current household issues. Secondly, the law has enhanced protection for victims through an introduction of Emergency Protection Order or EPO. Third, it grants the right of exclusive occupation to victims, which means the victims will have the right to stay in the house, not leaving the house. It's for the perpetrator to leave the house. Fourthly, the improvement of the Interim Protection Order or IPO and the Protection Order PO itself. And lastly, the introducing of the rehabilitation program for victims, perpetrators, and other family members. With this definition, it covers more act from the perpetrator that can be considered as amount to domestic violence. So how do we handle perpetrators then? First of all is by protecting the victims from the perpetrator. In terms of so the types of protection provided in the DVA covers EPO via 2017 amendment, IPO and PO. Emergency Protection Order, Interim Protection Order and Protection. In EPO, the perpetrator is prohibited from using domestic violence against the victim, from inciting any other person to commit domestic violence against the victim, and from entering any protected person's safe place, shelter, place of residence, shared residence, or alternative residence. EPO is provided in Section 3A via 2017 amendment. It is an order issued by the social welfare officer. Yeah? It can be applied at any time, whether or not an IPO or PO has been previously made, or an application for an IPO or PO is still pending. It can be any time. It works as in emergency situation. It is applied to a victim of domestic violence under Section 2A and B of Act 521. Yeah. It shall be made ex parte. That means it shall be applied by one party only, either the victim's counsel, or the guardian or relative or person responsible for the care of a child or an incapacitated adult, or a social welfare officer other than the social welfare officer authorized by the Director General. Yeah? Incapacitated adult is a person who is wholly or partially incapacitated or infirm by reason of permanent or temporary physical or mental disability, or ill health or old age, who is living as a member of the family of the person alleged to have committed the domestic violence, and includes any person who was confined or detained by that person. Yeah, for example, incapacitated adult suffering from autism, from mental illness, from physical incapacity, yeah, and so on. EPO application must be made in any district of the following, that is the victim residence or the perpetrator residence, where the alleged domestic violence occurred, or the victim placed temporarily. For example, the victim actually reside in Kuala Lumpur, but they are on travelling journey to Terengganu, and the domestic violence occurred in Terengganu. So EPO can be applied in the social welfare department in Terengganu. It can be in the place where the victim resides, the house, the home, or the perpetrator resides, or the place where domestic violence occurred, or the place where the victim is placed temporarily. For example, they go back to the hometown, and live temporarily in the hometown, balik kampung ke misalnya. IPO is an order that is sought in the court, pending investigations of domestic violence by the police. So IPO is application also made ex parte by the applicant's counsel, or the social welfare officer on behalf of the applicant. It is different from EPO in terms of the authority to issue the order. IPO is issued by the court, the magistrate, but EPO can be issued by the social worker officer. They have authority to issue EPO, the order to protect the victim in emergency situation. So that is the PO is a permanent order, or the protection order itself, which is issued by the court in a proceeding involved in a complaint of domestic violence. That means there must be a proceeding of domestic violence, and the court has a give decision, and the decision will include the protection order. The implication of protection order is to restrain the perpetrator from using domestic violence against the complainant or the victim. The court may also include a provision prohibiting the perpetrator from inciting any other person to commit domestic violence against the protected person. And the duration of PO is to have effect for such a period not exceeding 12 months from the date of commencement of such order. It is provided in Section 13, and by the amendment in 2017, it can be sought or seek by the victim within 7 days after the victim has been informed in writing by a police that the criminal proceeding relating to domestic violence will be instituted against the perpetrator, or at any stage of criminal proceedings under the penal code or any other written law law where the accused is charged with an offence involving domestic violence, whether or not an IPO has been issued against the accused. Yeah, so these are the situations where when protection order may be applied. Okay, who shall make application for protection order? Yeah, it can be applied by the victim's counsel, a social welfare officer on behalf of the victim, or a police officer on behalf of the victim. Yeah, so quite similar to IPO. The amendment of DVA in 2017 detailed out the orders that can be included in the PO and IPO, including granting right of exclusive occupation, yeah, to the victim in a shared residence by excluding the person against whom the order is made, by excluding the perpetrator. Number 2 is prohibiting or restraining the person against whom the order is made, yeah, on the perpetrator from entering safe place, shelter, place of residence, shared residence, alternative residence, place of employment, and school. Yeah? Protected person is permitted to enter a shared residence accompanied by an enforcement officer for the purpose of collecting belongings. Avoiding limiting the perpetrator from making communication by any means with any protected person. Permitting protected person to have continued use of vehicle, and giving any court direction as is necessary and incidental for the carrying out of such order. DVA also provide for counselling and rehabilitation program. Section 11 covers counselling as additional or substitute order to the protection order, that is to refer the parties to a conciliatory body. Conciliatory bodies shall submit report together with its recommendation to the court within 1 month, and the court, after considering the report and recommendation, can make order, can order one or more parties to be referred to rehabilitative therapy, psychotherapy, other reconciliatory counselling method as it deems appropriate. Yeah. The additional or substituted order for counselling is on the discretion of the court. Yeah. That is section 11. Section 11 in the amendment, and by the amendment in 2017, it includes rehabilitation program where the court may, in an application for protection order, make an order that to refer one or more parties to a rehabilitation program, either the perpetrator or the victims. But in order to refer the victim to rehabilitation program, it shall be made only with the consent of the victim. Yeah. DVA also provide for compensation award for victims, where Section 10 provides for the compensation where a victim of domestic violence suffers personal injuries or damage to property or financial loss as a result of the domestic violence. The court hearing a claim for compensation may award such compensation in respect of the injury or damage or loss as it deems just and reasonable. We hope that we can reduce domestic violence and we can handle the perpetrators appropriately and legally. So what we should do is to disseminate the information about the law on domestic violence to the public so that victims and members of the society will understand the law against perpetrators of domestic violence. Thus, the perpetrator will feel afraid to continue committing the crime. The awareness of the society is very important. The law can help stop the crime and help rehabilitating the perpetrator through psychological help and support of authorized parties. So through the rehabilitation program, counseling program, which can be made compulsory from the order of the court, it can be also rehabilitating the perpetrator. We should also empower the application of Domestic Violence Act, empower the DVA application and enforcement, and streamline protection laws for victims of domestic violence.
Assalamualaikum warahmatullahi wabarakatuh, and a very good day to all. Thank you for the opportunity to present my papers in International Seminar on Sharia and Law 2020. And My name is Ahmad Shukran bin Baharudin from the Faculty of Sharia and Law, USIM. I would like to present my papers. I have a few papers to be presented. The first presentation will be on the offense of spreading infectious disease and methods of proof through forensic science. The second one is systematic literature review of forensic science in prominent Sharia literature. The next one is forensic science in recent Sharia literature, a systematic literature review. And last paper is 3D, three-dimensional halal printed meat. Do we need new standards and regulation? My first presentation will be on the offense of spreading infectious disease and methods of proof through forensic science. As introductory part, there are several legislation and subsidiary legislation that are enforced and applicable in confronting the pandemic COVID-19 in Malaysia. Among it is the Prevention and Control of Infectious Disease Act 1988, or known as Act 342. This act has been enacted since 1988 concerning the prevention and control of infectious disease in Malaysia. The preamble to this act states that it was legislated to amalgamate laws relating to the prevention and control of infectious disease and to provide for other matters in relate to the act. And it applies throughout the country, not only for a specific place and state, but it applies to all Malaysian and also the person or any person who residing in Malaysia at the time it came into force. Since the implementation of MCO from 18 March 2020, there have been several reports of violations of orders that have been issued by the authorities. Most of the report were related to non-compliance with quarantine orders and others. However, until this date, there is still no offense in committing any act that could spread infectious disease reported in the social or mass media, and the study will discuss the possibility or discuss the offense of committing any manner that can be deemed to be spreading infectious disease to the public or exposing them with the risk of infection. This study also suggests several methods of proof through forensics, particularly forensic science, that can and have the potential or possible to be used in the conviction of such offense. This study used documentary materials as data in the process of mining data from document to obtain the information and related data, and the data obtained from the documentary material can be from primary or secondary document, depends on the source of the document being obtained, and the data were subsequently analyzed by using qualitative content analysis method. Findings, as for the acting in a manner that can spread infectious disease, we can divide into two, either the action that, if committed, can be convicted as an offense, or scientific evidence can be used in proving the action committed by the accused person. As for discussion, the offense of spreading infectious disease in civil law, there are three types of the offense as provided from the Act 342, or Section 3, Section 8, 9, 10 until 22, provides the offense of spreading infectious disease types that we can look into what kind of offense that are related to offense of spreading infectious disease. While in the view of in Sharia, from the Sharia point of view, the manner of harming others through infectious disease was based or is based on several hadiths, several prophetic hadiths. The first one is the hadith that narrated by Abu Hurairah, where in the translation, the Prophet say that there is no contagious disease is conveyed without Allah's permission, nor is there any bad omen, nor is there any hama, nor is there any bad omen in the month of Safar, and one should run away from the disease as one runs away from a lion. This is as reported by Al-Bukhari in the prophetic hadith number 5707, and from the second hadith narrated by Abu Hurairah, also according to Ibn Salah and Nawawi and Ibn Hajar Asqalani, it is possible to combine these two hadiths, for example, to bring out some aspect, direct person attention to that aspect, and endorse both of the hadiths. And it need to be done so that the higher intent of Muqasid Sharia contained in this proposition can be seen and understood more clearly. Based on this hadith, it can be combining because of these diseases are not contagious on its own, but Allah has made a person sick with this illness coming into contact with a healthy person as a means of infecting the healthy person with his sickness. The next discussion, how to prove the offense through the method of forensic science. It has the potential to be used in this case. Forensic science has the potential to be used in this case, as it will be used to prove an offense depend on the types of evidence found on the accused or the crime scene. Okay, as we said before, either from the medical reports, physical examination, biological examination, medical reports such as and also includes travel records from the documentary evidence, and also physical examination from the CCTV footage, and also digital finding or digital locating auto locating software such as maps and others also can be used as evidence of the physical evidence for the person to commit to the offense of spreading infectious disease. As a conclusion, committing an act which may be deemed to be contagious is considered as offense under subsection 12(1) of Act 342. However, things need to be taken into account if we want to enforce this subsection, because it involves the accused who is infected with an infected disease such as COVID-19. To make up this shortcoming, other evidence such as scientific or forensic science need to be used, and among the scientific or forensic evidence that this study considers potential to be used in proving offense being studied out: medical report, travel record, physical and biological evidence, examination, and CCTV footage. My next presentation will be in the topic of systematic literature review of forensic science in prominent Shariah literature, whereby in the study we use the same method to mine the data. We call it as data mining, and we provide the metric table for us to view from the different perspective. And it includes the integration or the interaction or the relation between the Qarina, forensic science, and special reference to the Maqasid Shariah. For the introduction, Islam of course represents faith, promotes sets of daily rituals, provide a set of guidelines on ethics and morality, and at the same time the use of intelligence to explore the world around us as using the scientific methodology and logic gives us or provide us with such an easy life to make our life become more harmony ways in harmony ways. And my second presentation is about the systematic literature review of forensic science in prominent Shariah literature. Islam, of course, presents a faith, promotes a set of daily rituals, provides a set of guidelines on ethics and morality, and a framework of reference or worldview. And it is indeed a spiritual guide to life, and it educates how to enjoy being alive in harmony with ourselves and the humans and the world. At the same time, the use of intelligence is to explore the world around us, and there is calls for utilizing scientific methodology and logic in our approach in order to appreciate the world. As for this research, the motivation to do this research is because of there are tens of thousands literature available in the shape of classical Muslim juries, with the variation of their opinion over its admissibility as their respective juristic approach. These various views are due to different methodology adopted by them in the interpretation and in the understanding of certain concept, context, and definitive of each case. According to Zuhaili, contemporary Muslim jurists, the argumentation given by the prominent Islamic scholars in relation to al-Qarina may be given into three different categories: either hudud cases, qisas cases, and mu'amalat other than hudud and qisas cases. So for this study, this qualitative study has collected relevant data from the data mining process. Data mining means we extract data, or we extract information from document, and we use documentary materials to provide the data, which is not much different from using interviews or observation. The nature of documents can be primary or secondary, depends on the source of the document obtained. And the data collected were subsequently analyzed subsequently analyzed using qualitative document content analysis. And the study also extends the literature towards appraisal of Maqasid Shariah in relation with forensic science and al-Qarina. Findings, we have come into conclusion that there are four prominent scholars of each madhab each school, Hanbali, Shafi'i, Maliki, and Hanafi. These are the results. When we go in depth of each literature, we found that there are lots of literature that discuss on the topic of Qarina and forensic science and the element of forensic science, either in civil or in criminal cases, muamalat or in criminal cases. For example, in the Hanafi school, the scholars having numbers of opinion in regard with the admissibility of Qarina, which is in the case of hudud, for instance. Abu Hanifah has agreed that a qarina of pregnancy is inapplicable for conviction in illicit intercourse cases, also refuses to acknowledge a qarina of breath and vomit as means of proof in intoxicant cases. However, he has accepted at the same time the drunkenness condition as circumstantial evidence or a qarina in the specific case. For example, the Maliki school have cited a lot about al-qarina in their writing. For example, Ibn Arabi say that in Maliki school they accept qarina as the mean of proof in most cases. And Imam Malik, for instance, accept a qarina of pregnancy for conviction in illicit intercourse case. And Al-Qayrawani offers the same opinion in his research. These are the examples from what we have found in the prominent literature of each madhab. We have explored on the Hanafi, Shafi'i, Maliki, and Hanbali school, and we found that it is there are quite different opinion in regard with each cases that have to be studied more, and there are also forensic science elements that have been highlighted in all the literature. And for example, the Hanbali school of thought, the qarina has been discussed in several sources of the school. For example, in the admissibility of the qarina, they have their own opinion. And in the case of pregnancy, for example, Ibn Qudamah and others, Al-Mardawi has not recognized qarina of pregnancy upon the conviction of illicit intercourse due to uncertainty. All of these differences in opinions were from the methodology of interpreting and understanding definite scripts. And from this literature, we found that there are interaction or relation between the forensic science and qarina in general, but not in specific, except for certain literature. And it displays that Islam, and especially Islamic law, truly recognize and appreciate the existence of science. This indicates that science and Islam are not strange. And based on the reviewed literature mentioned in above lines, it is evident that the assimilation between science and Islam existed. It does exist, and it is our job to explore, and it is our job to expand the research. And by referring to the metric tables, it portrays that the lack of discussion to relate forensic science and qarina, or both, with maqasid Shariah, owing to the fact that this field is still not in favor among the authors. And many scholars have clearly expressed that the application as well as appreciation of science and technology in Islam can be favorably viewed from the maqasid perspective. Next, for the recent Shariah literature, we have done also the systematic literature of the study, whereby we found a significant amount of literature that have done the work and have done the explanation, have done the study in the field of qarina, connecting qarina, forensic science, and also maqasid Shariah. The metric tables here and here display on how the literature connected to each review's area and scope. For example, Said Sikandar, 2005, 2006, 2007, Shabana, and others. For example, also Zulfakar, 1997, Mohammed Nur Daud also explained on the qarina in the view of Islamic and English law. And also Mohammed Nur bin Daud has included the understanding and interpretation of several elements of forensic science, such as voice screening and footmark traces, screening devices, and more. And also several books that discuss on the relationship between forensic science and qarina and others. In conclusion, we have come into conclusion that there are nevertheless 20% of literature discuss forensic science element to be related with qarina. 96 don't really relate it with maqasid Shariah. From these tables, also it is proof that the broadcast application of qarina can be found in two prominent Islamic schools of Maliki and Hanbali, then comes Shafi'i and lastly Hanafi. And when we highlight the maqasid view, it is the most essential intellectual apparatus and methodologies for Islamic law reform in nowadays academic literature. Thus, this study encourage academicians or any researchers to produce and publish more literature in relate with forensics and maqasid. My next presentation will be under the topic of 3D or three-dimensional halal printed meat. Do we need new standards and regulation? Whereby the study is a preliminary view on the 3D printed halal meat, whether we need to find or we need to build a new standard for this halal meat and regulation for it. The 3D process provides the ability to formulate innovative food items with enhanced nutritional benefit and sensory profiles, whereby this 3D printed process also include the food processing, including halal product. Nowadays, we use the 3D printing to print everything. We print we print everyday use thing, tools, mask, and anything can be produced from the 3D printer. Adding other binding elements such as gelatin in 3D printing process, we usually use substance or materials to bind between the layer. We print layer by layer, and then we use some binding mechanism to bind between the layer. Adding other binding elements such as gelatin that enhance meat processing will obviously subject to halal guideline and standard. Even if it is not related to the materials, also we have to look into the machine. We have to look into the process of building the meat. We have to look into the hygiene. We have to look into the packaging and others. In fact, issues like food safety also include the halalan tayyiban principle, where the manufacturer used hazardous machine component, as I said before, unsterilized petri dish and sharing machine for non-halal products are important to be addressed. So that this article reviews on the need to establish or to build or to produce new standards and regulation for halal printed product. 3D printing is the creation of the form of three-dimensional structure using a CAD model and digital 3D as a platform to create the 3D printed product. In order to manufacture this product, we use or we usually add together with it like liquid molecules, powder grains, being fused layer typically by layer by layer, and then we have to use some binding mechanism, and we have to wait until it be joined or solidified until computer control can also be regarded and as 3D printing as solidified with the computer operation. As for the history of 3D food printing, it is not new for us. It has started from the year of 2006 with the printing of paste extrusion by several manufacturer, several well-known manufacturer such as Nutella and others. Sugar printing by Evilmet Scientist Lab. Easy to chew and swallow senior food printing from paste by Biozone. Printing of advanced shapes by Sugar Capsule by 3D System in 2013. In vitro meat by Bioprinter by Modern Meadow in 2013 also. 2014, 2015, we managed to use 3D printed to print chocolate and also pasta. Nowadays, we are trying to print meat, biological printing of meat, and include all the nutrient and include all the nutrient needed by a person and print it from the 3D printer. Okay, the aims of 3D food printing is to manufacture 3D personalized food items with no tooling, molding, or human interference layer by layer. In this year, a lot of research in developing the 3D printing, expanding to pasta, pans, cheeses, frosting, cakes, cooking, and even the raw materials like meat and fishes. 3D printing and digital gastronomy are incorporated in food printing techniques, and also 3D printing is often adopted for creation of complicated structures in architecture form and not for cooking the ingredient. In this year, 2020, we have been informed that there are researchers managed to print fresh meat from the 3D printer, and the printing process started in the Israel country. Okay, example of 3D food printed product. We have meat, we have chocolate, we have pasta, we have meat kind of 3D printed food using molecules, and also we have the prototype of cakes. And issues, the first issue is short-term intake of 3D printed food could lead to adulterated or fabricated food. Due to this, legislation currently enforces the issue to food allergy by demanding the declaration of major like foods allergen to be declared on the packaging of 3D printed food. Recent regulation only includes the labeling or disclosure of 8 main dietary allergens, but it is an issue where the 3D printed food being disseminated to market. So how it's going to be on the packaging side? There is no rules or regulation in terms of declaring the 3D printed meat or 3D printed food in market. So if one or if a manufacturer managed to print fresh looking meat, for example, so and then they package the meat as usual meat, so it could lead to the fabrication or the adulterated food. We call it as fabrication or modification of adulterated food. Second issue, food printed product may contain infected substance. Okay, in the event that this occurs, the individual responsible for the pollution assume we put blame. For example, if the parties lack of ability to make a recall in order to prevent damage, so the company, the government should interfere. But there is no any standard or regulation to call or to recall back the product, and no provided provision to make the government interfere with this issue. And the third issue is allergy to 3D printing materials, labeling of traces. As I said before, in the case of mislabeling that resulted in food poisoning from allergies, the person responsible for the mislabeling will be liable for damage. So this one also has not being regulated. Hazardous in machine component. Machine component require safeguard when using different materials. Certain items may contain toxic and attract alien substance, and also attracts bacteria when it comes to contact with the component. So there are possibilities to get some food poisoning from the meat printed from the 3D printer. Speaking about the Malaysian protocol for the halal meat and poultry production, we only have this standard and regulation for halal meat, but we still don't have any 3D halal meat standard and regulation. If we allow the printing of meat, we don't speak about ethics right now. We are speaking about the standard and regulation. Let us say that if we allow the printing of meat, because to meet the demand from the market, to get into the market and to get it meat with the market demand, we have to produce more and more meat, and we have the technology to do it. So if we manage to have a big 3D printer machine to print food product such as meat in a big amount of the production, so how we are going to cater this issue, especially in the halal regulation issue? 3D printed food, while fresh, is still food after all. Thus, relevant law also would operate and probably regulate 3D printed food unless additional laws expressly governing 3D printed food are passed by the government in the future. In general, it depends on the printing products. No new substance are generated in 3D printing. 3D printing just bring materials into one type, but we have to take into consideration several issues in regard with internal halal control system of the 3D printed product. Permitted substance or material, halal permitted substance or materials used in the 3D printing process, halal inspection of machine 3D printer, especially for the 3D printer, halal 3D printing procedure, halal check on the product, dressing operation, as well as the previous halal meat regulation and standard, packaging, storage, and transportation to ensure halal 3D printed meat meet the requirement to become halal and tayyibah in the market. Current standard and regulation of halal processed meat need to be revised according to the technology and food science and engineering issues, including ethical issues, need to be addressed from different Islamic perspectives to provide strong foundation for 3D printing printed halal meat standards and regulation to be built and to be produced. This study suggests for further in-depth research to be conducted in the field, and urge scholars to view this as a fast-growing research field in halal studies. That's all from me for 4 videos presentation. Sorry if I have some mistakes in this video. Corresponding can be addressed to ahmadshukran@usim.edu.my. This work was supported by FRGS, 2 FRGS grants, and also 1 USIM grant related to COVID-19. Thank you, and Assalamualaikum warahmatullahi wabarakatuh.
بسم الله الرحمن الرحيم، والصلاة والسلام على أشرف المرسلين سيدنا محمد عليه أفضل الصلاة والتسليم. السادة أعضاء لجنة الإشراف على المؤتمر العالمي الدولي في الشريعة والقانون، تحية طيبة وبعد. عنوان ورقة العمل: الهجرة غير الشرعية في إطار القانون الدولي البحري. مقدم هذه الورقة الطالب سعيد سالم المزروعي من كلية الشريعة والقانون بجامعة العلوم الإسلامية الماليزية، التخصص دكتوراه في الفلسفة في القانون. بداية، تعد الهجرة غير الشرعية عبر البحار أهم الموضوعات الرئيسية التي شهدت اهتماما إعلاميا وسياسيا واجتماعيا هائلا في الآونة الأخيرة. يرجع ذلك لما له من آثار سلبية كبيرة على كافة المستويات والمجالات، حيث أن تأثيرها يطول كل من الدول التي يهاجر منها مواطنيها والمدن المستقبلة لهم، وبالأخص المدن الرأسمالية الصناعية المتقدمة في أغلب الأحيان. يتناقض مفهوم الهجرة غير الشرعية عبر البحار مع مصطلح الهجرة الشرعية أو الهجرة القانونية أو الهجرة العلنية، فالأخيرة يقصد بها انتقال الفرد من مكان نشأته إلى بلد مستقبل له بهدف الاستقرار، ويراعي المهاجر في ذلك كافة المقتضيات والإجراءات القانونية لهجرته. ومن هنا يمكن القول بأن الهجرة غير الشرعية عبر البحار أصبحت أكثر الموضوعات أهمية في بلدان العالم. سنتناول في هذه الورقة أولا ماهية الهجرة غير الشرعية، ثم نتحدث عن أركان جريمة الهجرة غير الشرعية. تعريف الهجرة غير الشرعية هو تعني الانتقال من الوطن الأم إلى وطن جديد يهاجر إليه بهدف الإقامة به بشكل مستمر عن طريق مخالفة القواعد والإجراءات القانونية التي تحكم القانون الداخلي والقانون الدولي. كذلك قدمت منظمة الأمم المتحدة تعريفا للهجرة غير الشرعية لأنها دخول غير مشروع لشخص ما أو عدد من الأشخاص لدولة ليسوا من رعاياها أو من المقيمين بها بواسطة عبور الحدود بدون الالتزام بشروط الدخول المشروعة لتلك الدول. نأتي الآن في القسم الثاني لنتحدث عن الأركان العامة لجريمة الهجرة الغير الشرعية. أولا، الركن المادي لهذه الجريمة، ويتمثل في ترك المواطن لوطنه الأم بطريقة غير شرعية. وينقسم هذا الركن إلى 3 أجزاء: السلوك الإجرامي، والنتيجة المعاقب عليها، ورابطة السببية. فالسلوك الإجرامي يتجسد في الهجرة غير الشرعية، أما النتيجة فهي عندما يتم ضبط هذا الشخص أثناء هجرته الغير الشرعية. أما العلاقة السببية فهو ما يقدمه المهاجر غير الشرعي عند ضبطه من خلال الوسائل أو الأوراق المزيفة، وهذا في حكم القانون يعني التدليس. الركن المعنوي ينقسم إلى قسمين: هناك القصد العام والقصد الخاص. ويتمثل الجانب المعنوي لجريمة الهجرة غير الشرعية في عملية خروج الأفراد من البلد الأم لدخول دولة أخرى والإقامة بها بطريقة غير مشروعة. وعلى سبيل المثال، حصول المهاجرين على التأشيرات ووثائق السفر من خلال منافذ غير قانونية، ومن ثم يقومون بمغادرة البلاد من خلال مراكز أو منافذ برية أو بحرية أو جوية. نأتي الآن في ختام هذه الورقة ونقول في النهاية نصل إلى أن ظاهرة الهجرة غير الشرعية ظاهرة معقدة وخطيرة بكل أبعادها القانونية والاجتماعية، وبالتالي لا يمكن القضاء عليها أمنيا، أي عن طريق اتخاذ التدابير الأمنية أو الإجهاض الأمني، وإنما للقضاء عليها يجب أولا البحث عن الأسباب المؤدية إليها باختلاف زواياها، وفي مقدمة ذلك يجب الاعتماد على التنمية. شاكر لكم حسن استماعكم، والسلام عليكم ورحمة الله تعالى وبركاته. بسم الله الرحمن الرحيم، والصلاة والسلام على أشرف المرسلين سيدنا محمد عليه أفضل الصلاة والتسليم. السادة لجنة الإشراف على المؤتمر العالمي للشريعة والقانون، تحية طيبة وبعد. عنوان ورقة العمل: المحكمة الجنائية الدولية ودورها في محاكمة مرتكبي جرائم الحرب. مقدم هذه الورقة الطالب سعيد سالم المزروعي من كلية الشريعة والقانون، جامعة العلوم الإسلامية، التخصص دكتوراه في الفلسفة في القانون. أما بعد، تعد المحكمة الجنائية الدولية بمثابة أول محكمة مستقلة ودائمة، وقد تم إنشائها طبقا لمعاهدة دولية حتى يتم وضع نهاية لإفلات المجرمين من العقاب، حيث أنها تمارس اختصاصها على أشخاص تثبت مسؤوليتهم في ارتكاب جرائم تصنف بأنها شديدة الخطر وتستحوذ على اهتمام دولي، ومنها جرائم الإبادة الجماعية، والجرائم التي ترتكب ضد الإنسانية، وجرائم العدوان، وجرائم الحرب. وقد استطاع المجتمع الدولي النجاح في أن يخرج للوجود أول محكمة جنائية دولية، يرجع السبب في ذلك إلى أنها تمتلك سلطة المحاكمة للمسؤولين عن ارتكاب الجرائم الدولية شديدة الخطورة. ويقع في نطاق المحكمة الجنائية الدولية محاكمة ومعاقبة من يقومون بارتكاب جرائم دولية خطيرة، والتي حددتها المادة الأولى من الفقرة 5 الواردة في النظام الأساسي للمحكمة الجنائية الدولية، والتي تنص على يقتصر اختصاص المحكمة على أشد الجرائم خطورة موضوع الاهتمام الدولي بأسره، وللمحكمة بموجب هذا النظام الأساسي اختصاص النظر في الجرائم التالية: أولا، جرائم الإبادة الجماعية، جرائم التي ترتكب ضد الإنسانية، جرائم العدوان، وأخيرا جرائم الحرب، والتي هي ستكون موضع ورقتنا هذه. أركان جريمة الحرب: تتكون جرائم الحرب من الركن المادي، والركن المعنوي، والركن الدولي، وسوف نتناول هذه الأركان بشيء من التوضيح. تنص المادة 8 الفقرة الأولى من النظام الأساسي للمحكمة الجنائية الدولية على أن اختصاص المحكمة بالنسبة لجرائم الحرب، وخاصة إذا تم ارتكابها في ظل خطة أو سياسة عامة أو حوادث ارتكبها بشكل واسع النطاق، مما يعني أن اختصاص المحكمة يكون بالنظر لأي فعل يمثل جريمة حرب بشكل عام. ويتكون الركن المادي في جرائم الحرب من الفعل أو السلوك الذي يعد بمثابة انتهاك أو خرق للقواعد التي تنظم سلوك الأطراف المشتركة في الحرب، ويساوي في ذلك كون تلك القواعد عرفية أو اتفاقية. ويتكون الركن المادي لجرائم الحرب من عدة صور تختلف من جريمة إلى أخرى، وهي كالآتي: في جرائم قتل الرهائن، في جرائم استعمال الغازات الخانقة، في جرائم الحرب البيولوجية، في جرائم استخدام المقذوفات والمتفجرات، في جرائم الاعتداء على المدنيين أو المقاتلين أو العزل. نأتي الآن إلى الركن المعنوي لجريمة الحرب، ونعني بالركن المعنوي لجرائم الحرب هو القصد الجنائي العام، والذي ينقسم إلى عنصرين هما العلم والإرادة، حيث إن الجاني يعلم بأن ما يقوم به من سلوك هو مخالف للقوانين والأعراف الخاصة بالحرب، وأن إرادته بارتكاب هذا الشيء عن قناعة، لذلك يظهر قصد الخاص وهو نية وضع حد للعلاقات الودية بين الدول. نأتي الآن إلى الركن الدولي لجرائم الحرب، ويعني بالركن الدولي لجرائم الحرب أن يكون وقوع جريمة الحرب قائم على تخطيط من جانب دولة متحاربة، وأن يقوم بالتنفيذ مواطنين تابعين لها، وفي حق رعاية من دولة الاعتداء، وذلك في أثناء نزاع دولي مسلح، وترتبط تلك الجرائم ارتباطا وثيقا بذلك النزاع. المبادئ القانونية التي تحكم عمل المحكمة الجنائية الدولية ضد مجرمي الحرب يتضمن عمل المحكمة العديد من المبادئ والقوانين التي تلتزم المحكمة الجنائية الدولية بتنفيذها وتفعيلها ضمن آلية عمل المحكمة، وتشمل أو أهمها مبدأ التعاون القضائي، أي هناك تعاون بين القضاء المحلي والقضاء الدولي من خلال مبدأ التكامل بين القانون الدولي والقانون المحلي. ختاما، لقد تحددت اختصاصات المحكمة الجنائية الدولية في الجرائم التي يتم ارتكابها ضد الإنسانية، وبالأخص جرائم الحرب، في حين أنها لم تحدد في نصوصها الجرائم المتعلقة بأسلحة الدمار الشامل وغيرها من الجرائم، الإتجار بالمخدرات وجرائم الإرهاب والجرائم المتعلقة والمرتكبة ضد الطبيعة. وبهذا أكون قد أنهيت هذه الورقة، وأتمنى لكم التوفيق، وأن أكون قدمت شيء بسيط في هذا الموضوع. شاكر لكم حسن استماعكم، والسلام عليكم ورحمة الله تعالى وبركاته.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First of all, I'm so delighted to be here in International Seminar on Sharia and Law 2020. So today I would like to talk about the paper entitled on Halal Industry and Islamic Finance Institutions' Role, Issues and Challenges. This paper is prepared by me, Najwa Alia binti Abdul Wakil, and Dr. Mohammed R bin Mas'ad Saleh. So now let's look on the overview or the outlook for the presentation today. So today I will present about the introduction for this paper, and then the research problem, and after that the research objective, and then the methodology which has been used in this paper, and then the finding and the conclusion. Now let's move on to the introduction for this paper. About halal. Halal is one of big businesses in today's world. The growing of Muslim population worldwide combined with the demand of halal products from non-Muslim has fueled the rapid development of halal industry. And taking into consideration the Muslim population and demand from non-Muslim customers for halal industry, there is greater halal products that need to be produced in order to meet the demand of both types of customers. And while for the Islamic finance, it can be defined as banking and financing based on Shariah guidelines and principles, the aims and operations of Islamic finance institutions are based on Quranic guidelines. Giving and taking of interest are prohibited from all transactions. Now let's look on the definition of halal industry. Halal industry can be defined as the whole ecosystem that related to Sharia compliant, and it is not just limited to food and beverages only. In Malaysia, there are 7 branches. We can see it on the diagram on the left side. Among them are halal in terms of food and beverages, logistics, premises, slaughter, tourism, equipment, medical devices, and others. But if looked at halal itself in Islam, this includes banking and in administrative work. So, as we know, now the world was plagued with the pandemic of COVID-19, and this pandemic also affect and shifting the dynamics mostly in the industry of tourism, logistics, and also banking and finances. However, the COVID-19 pandemic will have a more severe and deeper impact on Islamic finance markets, as the current crisis is affecting small and medium enterprises, as well as low-income and minimum-wage individuals, and particularly hard for them. Therefore, following the global financial crisis, Islamic finance has proven to be a resilient alternative to conventional financing. Islamic social finance solutions like Wakaf, Zakat, Islamic microfinance will help and provide liquidity access to small and medium enterprises and micro businesses for them to scale up their productivity. Thus, the problem statement occurs in this paper is the involvement of Islamic finance as financier to the halal industry is still at poor level due to few issues and challenges occurred like lack of understanding on the halal concept and regulation among entrepreneurs as well as poor awareness on Islamic finance system among halal industry players and others. Then, due to these issues, it will be difficult for the player to create the ecosystem of halal industry. And then let's look on the research objective. The main objective of this paper is to provide suggestions and opinion on dealing with issues and challenges in halal industry, and also to determine the issues and challenges in halal industry, and also to know the role of Islamic finance institution to enhance halal industry. And now let's look on the methodology which has been used in this paper. The researchers use qualitative research and it is divided into two sources, which is the primary sources. The researchers use personal interview, which the researchers has interviewed persons who are expert in halal industry field and also who are expert in Islamic finance field. And for the secondary sources, the researchers use document analysis instrument, which the researchers has reviewed many articles and books regarding and related to the issues and challenges on halal industry field and also on the Islamic finance field. Now, let's move on to the issues and challenges in halal industry and its solutions. First issues and challenges in halal industry is the lack understanding on the halal concept and law to Muslim as well as non-Muslim entrepreneurs. And the solutions, the authorities need to create halal workshops to enhance entrepreneurs and player understanding toward the halal industry, and also the authorities need to appoint a halal executive to advise entrepreneurs on the halal concept and law. And then the issues and challenges is the poor awareness on Islamic banking and finance institutions among halal industry players. And the solutions, the Islamic financial institutions need to give talks on Islamic financial products which can support halal industry in terms of financing. And also the Islamic financial institutions need to appoint a bank officer to provide free advice to halal entrepreneurs on the services they can provide. And then the issues and challenges in halal industry is the halal entrepreneurs use fake halal certificates. So the solutions, the authorities must conduct enforcement and inspections operations on the halal companies, and the public can file a complaint to the Ministry of Domestic Trade and Consumer Affairs if there has been a breach of the company's halal certificate. The next issues and challenges that has been found is the contamination of halal substances and impurities or illegal substances that do not follow the Sharia guidelines like pig's blood and carcasses. So the solution, it is mandatory for halal entrepreneurs to hear weekly religious talks in order to increase awareness on religious obligations, and the authorities need to do enforcement by doing continuously internal audit to the halal companies, and then on the issues to ensure a sustainable halal career in the future. So the solutions, it is compulsory for each company to apply for a halal certificate to ensure that there are job opportunities for halal career like halal executive. And then expanding network relations with foreign countries. And then the next issues is a few companies involved with applying Islamic Management System IMS, since most big business owners are from non-Muslims. So the solutions, by doing workshops by providing information and guidance to non-Islamic halal entrepreneurs on the concept of halal ecosystems. and it is compulsory for non-Muslim entrepreneurs to register their company with IMS. Now, let's move on to the finding of this paper. First finding is the Islamic banking and finance institutions are the source of financing to enhance and empower halal industry as well as to meet the current and potential demand for halal products. And then the understanding of Islamic finance is still low among the halal entrepreneurs due to lack of exposure to the concept of halal and law. And then the involvement of Islamic finance as financier of halal industry is still low due to the competition with big companies which mostly lead by non-Muslims. And then Tawarruk is one of the instruments provided by Islamic finance to provide financing method for halal industry in terms of working capital and investment. And channeling Islamic finance to halal industry for halal production will not only help in producing halal products and goods, but it will create new class of halal investment for halal income. Last but not least is the conclusion. In summary, the convergence of the Islamic finance institution and halal industry brings a huge potential for work opportunity to the public, helping in the growth and expansion of Islamic economies on global market as a way forward. This is in line with one of the Sustainable Development Goals, number 8, which is decent work and economic growth. Therefore, the issues and challenges in halal industry must be overcome to ensure the economic growth of both sectors. Thus, the two sectors of Islamic finance and halal industry investors need to harness synergies and achieve effective results through collaborative efforts to develop and promote their businesses as well as increase their economy. Thank you for lending your ears and time. That's all for the presentation on this paper. Thank you.
Assalamu alaikum warahmatullahi wabarakatuh. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Allahumma salli ala Sayyidina Muhammadin wa ala ali Sayyidina wa Maulana Muhammad. Respected Chairman and dear audience, my fellow presenters. First of all, let me thank Yusof for this very timely conference which will be conducive to locate the position of Islamic jurisprudence in facing the COVID-19. The title of my paper is Facing COVID-19 in light of the Islamic legal maxim, Qaida al-Fiqhiyya, no harm shall be inflicted or reciprocated. La darara wa la darar. Or the other usually used maxim related to this is al-darar yuzal, harm must be eliminated. And my co-author is Professor Mohammed Ali. He is from International Islamic University, Malaysia. In order to contain the spread of deadly pandemic, all governments across the globe exert their maximum efforts to break the chain of this virus. In this article, we attempt to discern what Islamic jurisprudence has to say in the crucial combat which causes this global crisis. We know that La darara wa la is a hadith which forbids self-harm and harm to others. And it is considered as one of the 5 prophetic traditions around which the entire body of fiqh revolves. This hadith prohibits all types of the harm, no matter whether if it is infliction or reciprocation, self-harm, harm to other, or becoming causative of harm. In view of some scholars, this maxim encompasses half of the fiqh, as fiqh is either for the purpose of achieving the benefit or repulsing the harm, beneficence or non-maleficence. Undoubtedly, this deadly disease is a severe harm which has already affected human life and all interactions in an unprecedented way. Moreover, we know that in the Islam, the protection of 5 things called maqasid al-Shariah is consensually perceived as the higher objectives of the Sharia. So the protection of the religion, body, intellect, progeny, wealth are considered as the maqasid al-Sharia. This pandemic, COVID-19, has posed fatal threats in the preservation of the aforesaid objectives. So through this paper, we attempt to create or formulate a fiqhi action plan in combating the COVID-19. Utilizing the Islamic legal maxims related to the harm elimination, we aim to prepare an action plan which will be effective and which will be influential for the people when they take the decisions or choices or their actions. The first step, this action plan contains of 6 steps. The first step is the identification of a considerable harm. In fiqh, an action or inaction is called considerable harm if it meets the 4 criteria, which are, first of all, the harm must be a reality, not just a kind of imaginary, and the harm should be serious. The minimal things of the small problems is a part and parcel of the human life. The harm should be al-darru an yakuna fahishan. Number 3 is the illegitimate way of infliction. The harm is posed through an illegitimate way. For example, the qisas, a person killed a person, so as a part of legal punishment for him in Islamic country, Muslim country, he will be also killed, the culprit. That is a harm for him, but this harm is not inflicted through an illegitimate way. So the infliction of harm is if it is an illegitimate way, then it is considered as a considerable harm. And the number 4 is that this action or inaction is causing damage to a valid benefit. Needless to say, the COVID-19 is a real and a serious harm. So its elimination or its prevention is considered as an obligatory duty of every believer. And causing this harm in a careless attitude or insensitive interaction comes under causing illegitimate harm, which is haram. So the causing harm through careless attitude includes breaking the rules of quarantine or breaking the rules of lockdown and other COVID-19 protocols. And as a part of identification of the considerable harm, the personally individual level and collective level, people should look into the contingent harms. For example, COVID-19 is a very evident harm. So once COVID-19 appeared in the world and it poses severe threats to different aspects of our life, we have to identify what are the areas where the COVID-19 is happening. So economic sector, health sector, hospital sector, or people's religious things. So all these harms should be identified in order to implement the next steps, which are considered as a step 2 in the fiqhi action plan of facing the COVID-19. The second thing is the prioritization of the containment measures. When we look into a dozen of Islamic legal maxims which are directly related to the harm elimination, we can categorize them into 3 groups. The first group of maxims is related to the prevention of the harm before its occurrence, and the second group is related to the elimination of a harm after its occurrence. And number 3 is the minimization of the harm. Not always we will be able to prevent or eliminate the harm in a complete way, so we have to be doing our duties to minimize the level of or its results of the harm. So when we look into the COVID-19 situations, first we have to the prioritization of the containment measures. If we have whatever ways we can utilize for preventing a harm, that is the first priority. Not always let the COVID-19 happen, then we will look into how we can eliminate the harm. No, that is not the fiqhi action plan for that. Fiqhi action plan is that first we have to exert our maximum capabilities for preventing the harm. The step 3, which is maxims related to the prevention. So there are 3 major maxims which are related to the aspect of prevention of a harm before its occurrence. The first is no harm shall be inflicted or reciprocated. La ضرر ولا ضرر. The health workers and society should be neither initiating any harm nor reciprocating with any harm. Awareness about this disease, its causes, consequences, remedies has a vital role in the implementing this maxim. Number two, in the step 3 is that harm should be avoided as much as possible. الضرر يُدْفَرْ بقدر الإمكان. The as much as possible means the people are ordained to do their maximum efforts, and they are not accountable for what is beyond their capability. So experts from the medical fraternity and disaster management have suggested several steps and strategies to combat this disease, and strictly following them is part of implementation of this maxim. Number 3 is the repelling harm is preferred to the achievement of benefits. Dar'ul mafsadati awla min jalbil maslaha. So the primary step in preventing infection is to know about how it spreads, and then only people can stay away from the causes. So if we have a choice, we can achieve a benefit in one way, we can prevent a harm in another way. We have to prefer the preventing harm. That is important in Sharia than achieving a benefit. So these are the 3 maxims which can be said as the governing principles in the prevention stage of anything. Particularly in this paper we are looking into the prevention stage of the COVID-19. Step 4 is the elimination stage. Once harm occurred, its removal or repair of the problems are obligatory, because harm is a mischief, and to allow to its continuance is another mischief. Usually harm is eliminated by removal of a harmful material, tort liability, and the legal punishments. These 3 methods are important in the case of COVID-19. In this step 4, which is related to the elimination stage of COVID-19, we can exclusively mention 3 maxims which are related to this stage. The first is harm must be eliminated, al-darar yuzal. The number 2 is al-darar la yuzalu bil-darar, or al-darar la yuzalu bimithlihi. These 2 things are with different coins of frames, but they are mentioning that a harm shouldn't be eliminated at the expense of causing on another harm. The number 3 is that al-dararu la yakunu qadiman. Lapse of time cannot justify the continuation of the harm. So in the elimination stage of COVID-19, these 3 maxims are really very important, and which will be governing principles for us. For example, the self-care, the treatment are among the best methods for the elimination of COVID-19. Having a proper rest, maintaining hygiene, and the drinking plenty of fluid and eating nutritious food, all these things are part of this stage we can consider. It's the list goes further, but because of the short of the time, I don't want to mention here which all these things are mentioned in my article, in our article. The step 5 is related to the minimization methods of unavoidable COVID-19 consequences. In those situations, fiqh frames 2 major methods to influence the decisions. Firstly, the greater harm should be prevented by forbearing the lesser harm. Its Arabic is al-dararu al-ashaddu yudfa'u bil-darari al-akhafi. Number 2 is the personal injury should be tolerated to prevent a general injury. يُتَحَمَّلُ الضَّرَرُ الْخَاص لِدَفْعِ الضَّرَرِ الْعَامِ. We have a lot of examples to mention here. For example, the usual and frequent examples, we want to go for the Jama'ah, we want to go for the crowd programs, but if these things are happening, if these things are becoming the reasons for the spread of this COVID-19, we have to incur, or we have to tolerate the personal loss or injury for the benefit of a greater majority out there. So the examples are many. I have mentioned a few of them in the article. The step 6 is related to take a decision which is harm-free or the least possible harm in our unavoidable situation. In this stage, the article has brought almost um, five other legal maxims which are related to the elimination of the harm, which helps us how we can make a decision or action or inaction harm free. For example, La ibrata lil darar ma'ajjala. No weight is given to the harm if it is inflicted with the contentment. Or necessities are estimated according to their quantity. Al-daruratu tuqaddaru biqadriha. Number 3, al-iltirar la yubtilu haqq al-ghayr. The necessity does not invalidate the rights of others. Number 4 is the hardship begets the facility. Al-mashaqqatu tajlibu taysir. Number 5 is contentment with lesser harm does not convey the contentment with the greater harm. Adillah bi adna al-dararain la yakunu rilan bi I mean the greater harm. So these are the 5 other maxims which can be mentioned or used in the stage of the step 6. So in this using this fiqhi action plan is very beneficial, not only from a religious perspective but also from facing and fighting against the COVID-19 in a fruitful way. So that's all. Inshallah, we can continue later on in the question answer session if there are any doubts or questions, and the details are mentioned in the article. Thank you very much for your patience. Barakallah fiik.